Good afternoon, everyone. It's not bright and sunny um, afternoon yet again. Weather seems to not be cooperating with us, but it is warmer definitely. And thank you for joining. We are discussing today this topic of the foreign investors ban, which came about. David, what was it like? Maybe 3.5 years ago or so,
Yeah,
um,
a
for
couple of years
two
ago.
years, right? It was for 2 years and then it was extended again. Really interesting topic because as we were discussing, David and I, a minute ago, it was not talked about in the elections at all from either party. It kept an eye and a year on it. I did do a fair amount of business with foreign investors prior to this ban. So some of us are affected by it, some of us are not. Market in general is not hugely affected by it because they said it's only about 4 to 5% that are foreign investors. Uh, it does give sort of a, you know, image of our market in a certain way. And I mean, I'll let David discuss this further and what the rules and regulations are, of course, um, associated with it. So over to you, David.
Okay, thanks, Sabiha. Thanks for joining us. Those of you that are with us live, and those that'll listen or watch this after it's recorded. Yeah, like Sabiha and I were just discussing before we got started here, like this still exists. So we're going to spend a little time today just going through what the current legislation is, because we're stuck with it for the time being. So we better make sure we're complying with it until there's a change. And it was quite interesting, as Sabia was pointing out, that it really wasn't raised. I don't think either of us heard anything during the election. When this first came out, it was easy for the opposition parties to just be critical of the liberals in power at the time and everything. But what nobody seemed to make it an election issue. Like, elect us, and we're one of the things we're going to do is get rid of the foreign buyer ban, or maybe they're going the other way. Maybe we're going to extend it. Maybe we're going to make it more restrictive. But it just seemed like the parties were all quiet about it, and the liberals weren't out there saying this has been in place for a couple of years, and here's all the benefits to us, how it's been working for 2 years, and here's the stats, and here why how it's improved the economy or whatever it's been. So it was pretty quiet. They did all the parties were commenting on the need for more housing and had different plans for increasing housing and how that affects the immigration policies because we don't want to have more immigration unless there's places for people to live. So those are sort of tied in together. So there's a lot on that, but nothing seemed to be very direct on the foreign buyer ban. So this is what we've got so far, and so let's learn how it applies and what we have to do until the government decides to make another change to it. And whether it's a good thing, a bad thing, or, for policy purposes, it's hard for me to comment on that. Other countries have imposed similar foreign buyer bans. Some are way more restrictive than what we have. Spain, for example, if you're a foreigner trying to buy a property in Spain, you have to pay 100% of the price as a tax, basically, to do it. So you're not banned, but you're going to pay twice the amount of the value if you want to do it. So effectively, like that's a pretty good ban. But here we've got a foreign buyer ban. You're prohibited if you fall under the category under the definitions of a foreign buyer. You cannot buy certain kinds of real estate. So that's what we want to go through, what those rules and regulations are. And I will spend some time also talking about the NRST, the non-resident speculation tax, just as sort of a refresher. Because people sometimes get confused between the foreign buyer ban and the non-resident speculation tax and their differences, and I'll explain all that to you. Main difference is this foreign buyer ban is a federal law. It's the federal government of Canada, the Liberal government of Canada, that imposed this. The NRST is a provincial law, so it applies to Ontario, and it's applied by the provincial government. And I'll get into a little more detail on that later on. So let's get into our slides here. I'll skip through some of the introductory slides. Other than I always make a pause here for the David and David on real estate. Sabiha, I think we have to update our pictures for this. I think one of us looks a little bit different. Actually, both of us, I think, look very different right now. So we should get these.
Certainly. Yeah, we'll
These
get
up.
that change for sure. Yeah.
Yeah.
Do we
Uh,
have a more recent picture of yours, David?
Probably not. I'm reluctant to provide a more recent picture of me. Not that I love this picture, but it's I think it only gets worse. So I might just live with this one. But anyway, and Dave and I did do some pictures in your office a little while ago that we were going to use, but I think we have to update even from that as well. So, anyways, that's just an aside. So, anyways, please check out our podcast. We recorded yesterday, I think, episodes 170, 171, and 172. We had a great guest on. So those episodes will be coming out over the next 3 weeks or so. We had a litigation lawyer, and it was quite interesting hearing what's going on about real estate deals gone bad, including one of our discussions was about a business representation agreement that had gone bad and was held to be not enforceable. So because things weren't explained, it wasn't done properly by the agent. So please tune into that one when that comes out. And we've also done this topic on many occasions. You can just look it up and check out in the table of contents and choose whatever episodes you want to watch. All right. So here's our introduction, just so you get a little bit of the history of this legislation. So this started, and the key thing to remember, this is a prohibition. This is a ban. It's not like you can be a foreigner and buy property but pay a tax. That's what the non-resident speculation tax is. This is a prohibition, and it was originally passed in June of 2022, and it was supposed to come into effect like 6, 7 months later as of January 1, 2023. And I don't know if some of you remember at the time, but we waited from June of 2022 when they first announced it until December 21, like literally 10 days before it was going to come into effect. We had no idea how this was going to work, what the regulations were, what the rules were going to be. We were all living in limbo land because the government didn't think it was important to us all to understand exactly what they're proposing. And then 10 days before it actually came into effect, they finally published regulations that were to govern it. So it came into effect January 1 of 2023. And then a few months later, there was some amendments because some of the rules and the regulations they produced weren't very clear. So they came out with some amendments in March of 2023 that came into effect that date. And and that's what we're living with. Now, it was initially proposed that there'd be a ban for 2 years, and then they were going to assess it and see the effect, et cetera, et cetera. I don't think they've ever published like, this is why it's so great, and this is why we should continue it, and here's the stats. At least I haven't seen anything like that. But they did decide to extend it. So instead of it just being from January 1, 2023 and ending on December 31, 2024, which would have been a 2-year period, it was extended till so it goes right to January 1, 2027, so effectively ending December 31, 2026. So we still have at least another year and a half of this, unless the government does an about face and either abolishes it or does a further extension or amendment. But there's been nothing that I've been hearing about a plan to change any of this. It's certainly not a priority at this point. I think they're trying to focus on getting more housing somehow right now. So anyways, that's the history of how this started. So we want to figure out, who does this apply to? Who is banned from buying real estate in Canada? So it's whoever is deemed by this law to be a non-Canadian. And they have different categories of non-Canadian, and this is all created by definitions within this act. So other definitions of non-residents and non-Canadians and other things that might apply to other acts are not the definitions that we have to look at. We have to look at the way they define what a non-Canadian is for the purpose of this act. So the easy one is the non-Canadian individuals, which is anybody that's not a Canadian citizen or a permanent resident of Canada or a registered Indian under the Indian Act. Okay, so if you're any of those three as an individual, you you don't have to worry. You can buy whatever you want. You're not prohibited. Okay, if you're Canadian citizen, permanent resident, or a registered Indian, you're not deemed to be a non-Canadian. It doesn't apply to you. And then when they do legislation like this, they're always looking to close up any potential loopholes before they even get started. So then they add a second category, foreign corporations. So a foreign corporation would be considered a non-Canadian. So those are corporations that are not formed under the laws of Canada or a province in Canada. So if you were not incorporated in the province of Ontario, or you're not incorporated in another province or federally in Canada, then you'd be considered a foreign corporation. So if you're a corporation formed in New Jersey, for example, you are a foreign corporation. Okay. Now, there's another category for corporations that are Canadian corporations that are formed in Canada, privately held Canadian corporations. So it applies to private corporations. So that means corporations not listed on the stock exchange, but any corporations that were incorporated in Canada, whether it's in Ontario or federally in Canada or another province, they're incorporated under Canadian laws or provincial laws, but they're controlled by a non-Canadian. They are deemed to be non-Canadians and prohibited from buying real estate. So one of the easy loopholes, everybody was thinking right away, oh, I'm a foreigner. I'm clearly an individual that can't buy in Canada. I'm not a Canadian citizen or a permanent resident. So I'll just get a company incorporated in Canada and buy it through that company. Well, no, you can't do that because the control of that company is by a non-Canadian, somebody that's defined as a non-Canadian. So that doesn't work. Okay. And there's another category for other foreign entities because they wanted to have other catch-alls. So it's any foreign entity. So it's a non-corporation, but any other type of entity that is controlled by a non-Canadian would also be considered to be a non-Canadian buyer for the purposes of this act and not allowed to buy. So those are the basic categories. So one of the key elements of this is how do they define control under the Act? What does it mean that non-Canadian is controlling a private Canadian corporation? So they had to go into that and define what control would mean for the purposes of this Act. And it's defined as there being an equity ownership. So there's direct or indirect, and indirect is a key word here, direct or indirect ownership of equity shares of 10% or more. Okay. So if someone had a small piece, less than 10% of a company, and the other, let's say it's 9%, and the other 91% was held by Canadians, that wouldn't prohibit the company, a private company. Okay, so it was 10% or more is the threshold. And then there's voting rights could be a determination where someone has 10% or more of the voting rights. So voting rights in a private corporation are usually by the common shares, but depends how the company is structured. And there's another category because they're trying to close any loopholes, and it's control in fact, and that's where there's direct or indirect control through ownership, agreement, or otherwise. So if someone is just saying, okay, I'm a non-Canadian, I'm trying to get around this, I don't want to be shown as owning equity ownership, or I don't want to be shown in the books of having shares that have voting rights. So I'm going to do a side agreement with somebody else and appoint somebody else through some other agreement, and I'll just be controlling them through some other agreement. So that's where they're trying to catch this control in fact, because that's not going to work, because they're going to dig down under each corporation to see who's really behind everything. And that's not going to work. You're not going to get around it that way. So anybody out there that's thinking, I should be trying to find a scheme to get around this, don't waste your time and energy. Okay. It's not going to work. So don't even go that route. We want to find out if our mutual clients are in fact allowed to buy based on the rules. If they are, great. If they're not, we tell them so, and they can't buy. And what I'm going to get into is it's not that they can't buy anything in Canada, it's that they can't buy certain types of real estate in Canada. Okay, so they could still be a client of yours and you could be helping them buy certain real estate, but there's certain things that they're not allowed to buy. So that's where we get into the next session, the types of residential real estate. So the first thing you should know is this applies only to residential real estate. So if you got a foreign buyer that's a non-Canadian fitting those definitions that wants to buy a commercial property in Canada, they're not subject to this act. They can do that. Okay. They can also buy certain types of residential real estate because they're not prohibited under this act. So the types of real estate that they cannot buy, the residential they cannot buy, are things like detached housing and small buildings containing not more than 3 dwelling units. And it could be a part of a building that's a semi-detached, a row house, a condo unit, that's part of a building. They cannot buy those type of things. That fits their definition of residential real estate, and they're prohibited from buying that. Okay, now they have an exclusion for even real estate that would fit in that, and they're saying if you buy in certain areas in Canada, then you will not be prohibited from buying even those types of residential real estate. And they came up with this, I find it rather convoluted description that's not easy to understand. And it's a consensus metropolitan area and census agglomeration. So there are certain pockets in Canada where they say, if someone's going to buy in these remote areas, and it's basically for areas that are outside major centers in Canada. They say, okay, if you're going to buy residential real estate in some of these remote areas in Canada, we don't have a problem with it. So we're not going to prohibit you. So anybody that's looking to buy something and they're otherwise fit the definition as a non-Canadian that would normally be banned, we also have to look at exactly what property they were going to buy and see where that is and see if it fits under these definitions of the census metropolitan area or census agglomeration. And there's a map that they produce, and you can go in and look at it. And so you can see, it's hard to see in this because I know it's small, but there's areas even within Ontario where people, non-Canadians could potentially buy residential real estate. Okay. But suffice to say, it's not going to be in any of the major urban centers or towns. It's really going to be more on the outskirts. So just to make our lives a little more difficult. So it's never easy, a black and white answer for any of this stuff. Can they buy this property? We got to go and look and see exactly where this property is and see if it's in one of these areas that's excluded from the prohibition. This is a little bit of a closer look, but it's hard to do. Anyways, you'll have this in the materials, but anybody that's looking to act for somebody that's considering it, we'd have to see exactly where the property is that they're looking for and just see if they can buy that residential property out there. So those are exclusions if they're in those areas. They also put into the act certain exemptions. So again, an exemption would be for someone that would otherwise be banned because they'd be considered a non-Canadian, but they might fit under one of these exemptions, and therefore they would not be prohibited and they'd be allowed to buy these residential properties. So the first exemptions for an individual who's purchasing a residential property with their spouse or common law partner, if that spouse or common law partner is not prohibited under the act. So they are Canadian citizens, or they are PRs, or they're Indians under the Indian Act. So their spouse or common law partner is not prohibited. They're buying it together. So the non-Canadian would be permitted to go ahead. Okay. The fact that there's a non-Canadian spouse buying it with the Canadian does not taint it and make it a property they cannot buy. It goes the other way. They get an exemption and they are allowed to buy it with their spouse or common law partner. The second category of exemptions was for temporary residents in Canada, as long as they comply with certain conditions. And there's a category for students, and there's a category for workers. And and I'll go into a little bit of detail on that in a second. So if they fit into one of those temporary resident categories, they could qualify for an exemption and be allowed to buy as well. And then there's another exemption category for persons prescribed by regulations, which would cover things like refugee claimants and people that are members of a foreign mission in Canada. So there might be other exemptions. So depending on whether you have a client that might fit into a category like that. So let's go in a little more detail about the student exemption. So the student would have to be enrolled in a program of authorized study as a designated learning institution. So the government actually produces a list of learning institutions that are designated that are good. So you can't be enrolled in some Mickey Mouse learning program that hasn't been authorized and authorized. That's not considered an authorized study area by the government. Federal government is not on their list. But if they're on their list, that's the first test. They have to be enrolled in one of those designated learning institutions. And then the student has to file income tax returns for each of the 5 taxation years preceding the year that they buy. They have to be physically present in Canada for at least 244 days in each of the 5 years preceding the year that they bought. The purchase price can't exceed $500,000, and they cannot have previously purchased a residential property while this act is in effect. So when I look at all of those conditions, I can't think of anybody. I don't know. I haven't come across anybody that would fit all of that exemption. So it's possible someone could be exempt, the right fact circumstances, but you can see it's sort of a high bar to qualify for all of those conditions and fit that. And then they also have this workers exemption. So a worker has to hold a permit, a work permit, so they're authorized to work in Canada. They have to have 183 days or more of validity remaining on their work permit or work authorization on the date that they buy. So if they're buying today, their work permit can't be expiring in 182 days from now. They wouldn't qualify. If they still have at least 183 more days, then they could qualify that way. And again, they can't have previously purchased a residential property while this act is in effect, meaning they can only do this once. Okay, they're otherwise prohibited, but if they have a valid work permit that still has enough days remaining on it, they can do this once. They can be exempt one time and buy a residential property. So again, sort of a high bar. I don't know if we've done any transactions for anybody that really fit under that in the couple of years that this has been in place, but it's possible. There is that exemption. So the other thing is they have to define, what exactly is a purchase, because they're talking about, the date of purchase and when there's a purchase. So they actually define what that means for the purposes of this act. So a purchase is an acquisition with or without conditions of a legal or equitable interest or a real right in a residential property. That is what a purchase under this act. So one of the key things here is with or without conditions. So if someone has entered into an agreement that still has conditions, that's considered to be a purchase, even though the conditions haven't been fulfilled yet. So if there are any pre-existing contracts that arose, that to a non-Canadian that were prior to this ban coming into force, January 1, 2023, they would not be subject to the act. So if someone bought a pre-construction condo unit prior to this coming into force in January 2023, they're allowed to still go ahead with it. Okay, it's not prohibited. So we can still go ahead and close as long as the agreement was signed prior to January 1, 2023. So we still have a bunch of those out there because there's a whole bunch of projects. There's some detached projects. There's a bunch of condominium projects where people did sign prior to the ban. So those people will be allowed to complete their transactions. If they sign, for anybody signing after January 1, 2023 that would otherwise be prohibited, their deals will be terminated. They cannot do those and complete those deals. Okay. The same thing applies to assignments and assumption contracts. We have to look at the dates when they were signed and assigned to somebody. So that's the key date, January 1, 2023. If it was signed prior to that date, the government doesn't stop those transactions from going ahead. So we have to look on that case by case basis and see what the actual dates were for the agreements. Now, there's some other exceptions for when things would not be considered to be a purchase under that definition. So if someone acquired an interest in a property as a result of a death or divorce, or a separation agreement, a divorce decree, or as a gift, that would not be considered to be a purchase. So if they acquire that interest by one of those means after January 1, 2023, they wouldn't be prohibited from owning that property. Okay. But if they're acquiring it pursuant to one of those things, but yeah, death, divorce, separate, they're not paying for it. Okay. They're not really buying it. They're acquiring the interest. So if someone's paying for it or buying it, then they're going to be prohibited. But if they're acquiring it as a result of one of these things, they're getting an interest in it. That's not banned by this. So a non-Canadian could acquire residential real estate in Canada subsequent to January 1, 2023 if they're not buying it, but they acquired it because it was left to them in a will or pursuant to a divorce or a separation agreement, or it was gifted to them. And obviously, the government's going to look at the documents that do any of that to make sure that they're legit. And it's not something that was just being created in an attempt to get around the legislation. And if they smell or sniff that there's been any money flowing from one side to the other, they're gonna terminate it, and there's consequences for that. A second exemption when something's not considered a purchase is a rental of a dwelling unit to a tenant for occupation by the tenant. So rentals, you're allowed to, if you're a non-Canadian, you're allowed to rent a residential property. That's not a purchase. If the transfer is done under a trust that was created prior to the start date of January 1, 2023, there could be an exemption available. Transfer resulting from the exercise of a security interest or a secured right by a secured creditor. So if a secured creditor has lent money or whatever to somebody, and that secured creditor is a non-Canadian, and then there's a default, then that secured creditor is enforcing their security interest and takes over the ownership of that property. For example, they foreclose on a lender forecloses on a property. Instead of selling it under power of sale, they choose to take the ownership interest in the property. So that's them exercising their security rights. So they're not banned from doing that. If the documents and the facts actually support that. And each time the government's going to look in and make sure that it's accurate and the documents and everything support the accuracy of that. And also, if a property is being acquired, a residential property for the purpose of development, that could fit under another type of exemption as well, where it wouldn't be considered a purchase of the property for residential use, because that's what they're sort of targeting. Are you buying this for residential use, or are you buying what was a residential property that would have fit on a definition, but it's really being bought to tear down and redevelop the property? There's an exemption that could be available. So that's what a non-Canadian can do that, because they're trying to avoid the non-Canadian buying the residential property and living in the residential property.
I have a question about that. Sorry, David,
Mhm.
if I may, very,
Yep.
very quickly. So the last point, so somebody can buy a residential home for the purpose of a land and then
Mhm.
rebuild on it like a residence, like a singular
It
residence, or
depends on what they're gonna do in terms of what development. I think the original legislation was sort of contemplating more that, a developer is buying up, 4 or 5 homes to tear them down and put up a condo or something like that, a different type of development. If it's just a one-off, they're tearing down this house and putting up another house, it might not fit their definition of development. They might consider that to be just another residential. But I don't. That's a great question, Sabine. I'm not sure what the answer is or how they're dealing with that.
got it.
Okay. Now, I want you to pay attention to this section because this applies to you as a realtor, it applies to me as a lawyer. They were very strict in the legislation in putting in very specific enforcement and penalties, which is why I've been sort of telling you, like, be careful with doing this and don't look for loopholes and ways around this legislation, because they put provisions right in there that says that anyone knowingly counsels, induces, aids, or abets in a contravention of the act or attempts to do so, attempts to help someone to do so, is guilty of an offense and liable on conviction to a fine of up to $10,000. So what they're trying to do is give fair warning to me and you, us as lawyers, all my staff, my law clerks, everybody in my office that could be providing any advice to someone that's trying to get around this act. And the same thing to you, anybody in your office, you as a realtor, anybody at the brokerage that is counseling, aiding or abetting or attempting to counsel, aid or abet anybody. You could be personally liable for a fine up to $10,000 for doing that. Okay. If a corporation or entity commits an offense, the directors, officers, managers, supervisors, agents who have directed or assented, acquiesced, or participated in the contravention may be personally liable. So you can't even be doing this through a corporation. They can go after the officers and directors. So the potential liability for this $10,000 fine extends to developers, anybody selling a property, assinors, lawyers, professional buyers, real estate agents, notaries, mortgage brokers, anybody involved in the industry that might be providing some advice. So we all have to be very careful in what we're doing. Okay, which creates an issue for us because we're being asked by our mutual client who might be a non-Canadian and prohibited from buying this act. They're asking us, can I buy this? And so what we have to do when we're in that situation is we have to get all the information and get all the facts, but then you have to be careful not to cross a line about and potentially participate in any type of scheme or anything that's really trying to get around it. So we got to be careful in the advice that we're giving, how we're giving the advice, the notes we're taking, and all the fact finding that we're doing. And you can't be blind in what you're doing as well. You can't say, I don't want to know all the details. I don't want to know all the facts. I don't want to ask you certain questions because I think I might not like the answers that you're going to give to me and be blind to it. Okay. That is not fulfilling your responsibility, first of all, and your compliance with your obligation as a realtor. And I wouldn't be compliant with my obligation as a lawyer if we're trying to do that. So this does put us into a potential conflict situation because we are being asked these questions all the time, and we just have to be careful in the way we deal with it. So when I'm asked these questions, and I get asked all the time, oh, you know what? I just want to run something past you. Here's the situation. I'm acting for a potential client, or I have a client. Here's a story, and I want to know if he's a Canadian or not Canadian. It's never an easy answer for me to give, and it's never a 5-minute discussion. Okay, we have to be very careful in the way we do it. We have to be formally retained. We have to get all the facts and information. We got all kinds of questions we have to ask to determine whether or not they are considered non-Canadian, whether or not they would fit under any exemption, whether or not, what their marital status is, have they bought properties previously? Like it goes on and on. There's a whole bunch of questions that we'd have to ask to determine whether or not they're non-Canadian, then look at the type of property they're buying, and then see how they're buying it, who they're buying it with, etc. And we got to be careful in what we're doing, how we're documenting the answers and the information that we're getting before we can give an answer. So understand that, and you should be taking the same approach. Okay, you should never be, if someone's asking you at a cocktail party, oh, you know what, I was thinking of maybe buying a property through you, or my cousin is, but he might be a non-Canadian. I don't know if the foreign buyer bought a plan, and they ask you a bunch of questions. Don't give answers like that in a cocktail party. Okay, you want to be formally retained. You've got to go through a process and ask all the right questions. And one of the reasons is because you potentially could be personally liable for $10,000 if you're involved in unwittingly sometimes in a scheme or an attempted scheme or some attempt to contravene the act. So just be really careful what you're doing. Okay. Now, sometimes, what do we do if we find out we've got someone under contract, turns that they're buying a property, and now it turns out they're a non-Canadian. So we can't really help them complete that because now we're helping and they'd be in contravention of the act. We're providing services, you as a realtor, me as a lawyer, in convection and in contravention of the act. So now not only are we not helping out this client because the transaction is going to be terminated eventually anyways, but we're putting ourselves on the firing line because we can be personally liable to fines ourselves. So it's a fine line and a conflict position because um, we have an obligation to try and give advice and try and get a transaction completed, and refusing to do so, we can be in breach of our professional obligations. On the other hand, in helping them, we are definitely going to be in breach of our professional obligations and in breach of our obligations that are imposed on us personally under this act. So we got to be very careful in how we deal with these type of situations. So there are some steps that can be taken to avoid knowingly assisting and willful blindness. Willful blindness is just as bad. You can't be willfully blind and say, no, I don't want to know, don't tell me, I don't want to hear, I don't want to ask all the right questions. So be careful doing that. Okay. So we got to be at, so the steps, the way to avoid it is by asking the right question, by getting representations and warranties from buyers that to the effect you want them to represent and warrant to you that they are in fact permitted to buy it. They are not considered non-Canadians under the act, so they can buy. So you can go through with a purchase. When you're on the sales side of a transaction, you want there to be a rep and warranty in your agreement of purchase and sale by the buyers, saying that we represent and warrant that we are allowed to buy this property. We are not non-Canadians. Otherwise, why is the seller going to waste their time selling to them, losing the opportunity from selling to people that are truly non-Canadians, and then entering into this agreement with someone who turns out to be a non-Canadian, and then the agreement can't close, and you've wasted a lot of time and energy and money. So we want there to be representations and warranties from buyers. And why would a buyer who is a Canadian or is not not a non-Canadian refuse to provide a rep and warranty? If they're going to say, I don't want to sign that, then that should set off alarm bells, because obviously they're not being upfront, because they're probably not going to be allowed to buy this. So that's the number one way that we're going to avoid this. Okay. So we got to be careful with these things. Sometimes I'd like to try and take it a step further and say, hey, buyer, rep and warranty is not good enough. I want you to indemnify us as well. I want you to indemnify the seller. I want you to indemnify the seller's agent. While you're at it, you might as well indemnify the seller's lawyer. You can indemnify the buyer's agent, the buyer's lawyer, because we're all involved in this transaction, because we're relying on you telling us that you're allowed to buy this property. You're not prohibited. If it turns out that you're lying to all of us could be potentially liable to the government for a $10,000 penalty. So please provide us with an indemnity and put your money where your mouth is. And again, if they're going to say, no, I don't want to give you an indemnity, like, why? Okay, that should set off alarm bells. Okay, so important thing to do, it'd be great if we can get the rep and warranty. It's great if we can get the indemnity, but you got to be asking all the questions, make all the inquiries that you have to determine whether or not the buyer in a transaction might be a non-Canadian. And if you get a whiff of that, it might be, then you got to go further. And then we got to see, okay, maybe they are non-Canadian. Maybe there's an exemption that they could fit under. Or, maybe the property isn't considered a residential private purpose of the act, and then you're fine. You don't have to worry about it. So, that might be the starting point. Okay, know the property that you're dealing with, and see if that property can be sold to a non-Canadian or not. So that's another way to start. So now, if the government finds out that a property was purchased in contravention, they'll go to court, they'll get an order, they'll stop the transaction, and they'll unwind it, undo it. They can impose penalties and costs against the parties involved. But it's going to get found and it's going to be undone. Even if it closed and they find out after the fact that it closed, they can go to court and unwind the transaction. And then the question is going to be who's the property going to go back to, and what happened to the flow of funds, and what happened to the mortgage that was issued for it, etc. Okay, so if there was a mortgage on the property, so it becomes quite complicated. Now I want to use the remaining time that I have to talk to you a little bit about NRST, just as a refresher. So again, the NRST, non-resident speculation tax, is a provincial law, okay? And it has its own definitions and of who it applies to and how it applies. So the big difference between the foreign buyer ban and the NRST is the ban is a ban. You're not allowed to buy a property if you're a non-Canadian and it's a residential property under their definition. You can't buy it. And if you do buy it, they'll unwind it and terminate the transaction, and it's not going to happen. Okay. The NRST says if you are is someone that the act applies to, then you can buy it, but you have to pay a tax. So you're allowed to buy it, you're not prohibited from buying it, but you have to pay a tax. So when this act first came in, again, it has its own definitions. It was an individual, corporation, entity that's not prohibited from purchasing residential property. Can buy it, but they got to pay the speculation tax. Okay, so this applies to buying the property or an interest in a resident. Again, this is residential property. It's got nothing to do with commercial properties. Residential property by someone considered to be a foreign national or a foreign corporation or a taxable trustee. And those are there's definitions in there of what those are, which are different definitions from what a non-Canadian is under the foreign buyer ban. Now, the NRST, when it first came in, the law came in and then there was some changes and amendments to it. So the whole key is when was the agreement of purchase sale signed? So if the agreement of purchase sale was signed on or after October 25, 2022, which is the most recent change, the current tax is 25% of the purchase price, and it's for any residential property in Ontario that's bought by someone that's considered a foreign national that has to pay this tax. Okay, 25% for any residential property from October 25, 22 forward. So when this originally came in, you might remember the agreement was signed prior to March 30, 2022. It was only a 15% tax, 15% of the purchase price, and it didn't apply to properties everywhere in Ontario. It was just in a defined area, which was called the Greater Golden Horseshoe region of Ontario, which was basically the Greater Toronto area and extended around to the Niagara area, like the Golden Horseshoe area, and extended to the outskirts of Toronto up to some of the cottage country, but not all the way up north. So I think Orillia, Barrie may have still been part of it, but it didn't go all the way to Muskoka, or it may have been up to Barrie, but not to Orillia, something like that. And the same thing east and west. Then in March of 2022, they changed it from 15% to 20%, and it said if it's a property anywhere in Ontario, forget about the Greater Golden Horseshoe area. And then in later that in October of 2022, they changed it from 20% to 25%, which is the current law. Okay, so this applies to any individual that's not a Canadian citizen or a permanent resident of Canada. It applies to foreign corporations. It applies to taxable trustees. Again, remember, they're trying to close loopholes before anybody can consider them. Okay. And
David, may I just ask a quick question
Yep.
first? The people that can buy for being foreigners, so say you have a spouse that's Canadian and you are allowed to buy under that regulation, you will have to pay this tax?
Yes. Great question. Yeah. So when we get asked these questions, first thing we try and figure out is, are they banned? Okay. Yes, they're banned. Do they fit under the exemptions? No, they're still banned. Forget it. They can't. Now, if it's someone that would otherwise be banned, but they fit under an exemption, so they're allowed to buy, great, you can buy, but but if it's Ontario and you fit under one of these definitions under the NRST, then you could buy, but you have to pay the tax. Okay. And then there's certain exemptions that I'm going to talk about too, where you might not have to pay the tax if you fall under one of those exemptions under the NRST. Okay. And that's why I'm saying these questions are never 5 minute. Just I need 5 minutes. Got a quick question for you. So don't be sucked into trying to answer something like that. Every time we get a question like this, we go through quite a process to try and figure out whether or not it applies, whether or not there's an exemption on the foreign buyer ban. If they pass that hurdle, okay, now you can buy in Ontario. Do they have to pay the tax? Do they fit the definition? Someone would have to. Okay, great. Maybe there's an exemption. Let's look at the exemptions. Maybe they don't have to pay the tax. Maybe they can fit under an exemption, or maybe they fit under a rebate. So there's exemptions under the NRST. There's 3 types of exemptions: a nominee exemption, a refugee exemption, a spousal exemption. I'm not going to get in details of all that because it'd take me an hour to do that. But we go through a process sometimes. If someone would otherwise have to pay the tax, maybe they will not have to because they might fit under one of these exemptions. And then sometimes people have to pay the tax on closing. They got to pay the NRST. They pay it on closing. When the NRST is payable, it has to be paid. You cannot close a transaction without it. Actually, we had a transaction last week where we're coming to closing. Someone has to pay the 25% tax, okay? Have to pay the NRST. And we have to pay it on closing. We're not allowed to register the deed unless we pay the government that 25% on closing. But their agent told them at some point, you don't have to pay it on closing. You can pay it over time. You've got a couple years to pay that tax, and you don't have to pay it on closing. So they were relying on the agent's advice and ignored the advice that we gave them because we sent them letters that outlined that they have to pay this on closing. And we're coming up to the closing date, and sure enough, they don't have the money because it's 25%. So it's not like an insignificant amount of money, and they don't have it. Oh, I don't have it because my agent said I could pay this off over time. There's like a layaway plan that the government has or something like no. And the agent gave really bad advice, and we try really hard, as you guys know, to never be critical of agents that we work. We're always trying to support you. We're always trying to make sure you're on top of things, and you're never giving an answer like that. And we support you. We never want to throw anybody under the bus. But this made it very challenging because the agent explicitly told them you do not need that money for closing. You can close the transaction and you can pay the government that 25% later on, which is not accurate. So it created a real problem. So anyways, there are exemptions we're looking for. There's also rebates. Sometimes you have to pay the pay the tax on closing. You got to pay that 25% on closing. They get title to the property. It's their property, et cetera, et cetera. But they might qualify for a rebate. And there are certain rebates that are available. And that means they paid the tax on closing. But if they qualify after closing for a rebate, then we can apply to get that rebate back. So it creates a cash flow issue because they got to pay it on closing. They might qualify for a rebate down the road. So if the agreement was signed prior to March 29, 2022, and it was within that greater golden horseshoe, there were certain rebates that were applicable for an international student or a foreign worker under a work permit in Ontario. So some of that might still be out there. There might still be an opportunity for someone if they signed their agreement prior to that date and they were an international student or a foreign national under valid work permit, and they met other conditions, they might be able to get that rebate back. Okay. But when they changed the NRST law in March of 2022, any conveyance after that date no longer has those rebates available to students and workers. Okay, they no longer apply. They got rid of that. So there is still another rebate available. The only one that's still available is if someone became a permanent resident of Canada after closing I think it's within 4 years, you become a PR after closing, you can apply then to get the rebate. Say, hey, I closed the deal on May 29, 2025. I paid the 25% tax. 3 years later, 4 years, up to 4 years later, you became a PR. Here's all the documents. Here's all the evidence. Here's my application. And if you fit all the conditions, then that rebate is still available to someone who becomes a permanent resident after closing, that paid that tax. Otherwise, you got to pay the tax. So with all of this, I hope I've impressed upon you the fact that there's a process in determining all of this. It's not easy. It's not clear, black and white. So if you're working with anybody that's potentially someone that'd be banned by the foreign ban, let's start with that. First thing to do is you have the discussion with them. What type of property are you looking to buy? And where are you looking to buy it? If it's a commercial property, you don't have to worry about the foreign buyer ban. Okay. If it's a residential property, then it might be applicable depending on where the property is located. And then you could go through the process of determining, are they in fact under foreign buyers under the definitions? Is there a potential exemption available to them? And we go through that process. And then if you can move ahead and you determine they're not banned by it, we have to consider the second element, which is the NRST. They may not be banned, but depending on the type of property they're buying and where they're buying it and who's involved in the transaction, it could be subject to the NRST, which means they can buy it, but they got to pay the 25% tax. And that has to be paid on closing. There's no layaway plan. So don't ever tell anybody that there's a layaway plan. You can pay this over time. It's got to be paid on closing. 25%. It's not a small amount. Okay. Now, if that potential client of yours is working towards becoming a PR, then great. You can let them know that too. If they become a PR within the time frame under the current law, then they might be able to recover that tax that was paid. But there's no easy, simple, shortcut answers. And we get questions all the time. Here's the situation. Here's how they're doing. We're doing it through a corporation. Trying to create a trust to do it. Okay. We got to look at it because more often than not, the answer is going to be it's not going to work because they'll be deemed control by whoever would be considered a non-Canadian. They're still controlling that corporation or they're controlling that entity or they're controlling that trust or whatever they're trying to draft up by way of a side agreement, and it's not ultimately going to work. And we've got to be, as I mentioned a few times already, you got to be very careful in the advice you give and how you give that advice and all the note taking and everything else that you do, because you could potentially be personally liable. In addition to the transaction being undone, you could be personally liable to a fine for $10,000. So you don't want to put yourself in the line of fire that way. So with that, Sabi, I'm going to send it back to you. There might be some questions.
David, I have a question.
Okay.
So what if it's a commercial unit and there's a residential property above it
Mm-hmm.
that's all part of it?
Yeah. Yeah. So the residential component of that would be subject to it as long as it meets the definitions of what a residential property would be, then that could be prohibited.
Okay. Thank you.
Yeah. So Gabby, like something that is commercial but residential is good example of that is a multi-unit. So up to 3 units is residential, but if there's 4 or more units, it's deemed to be commercial. So they can purchase 4 or more. But I would, err side of caution when it's those one shop, one residence units for sure.
Yeah. And sometimes the best advice you can give clients are looking to buy one of these properties is no, let's find a property that you can clearly buy. That's clearly a commercial property that you're not prohibited. Because why would anybody want to get involved in having a transaction unwound by the government of Canada and incurring all those costs and court orders and court applications and everything. It's not worth it. And certainly it's not worth it to you, for that commission when you can just go find them a commercial property, a property that's clearly commercial, or a multi-tenanted property that is outside the definition and the prohibition. It's got, an apartment building. They can go buy apartment building if they want, if it's got 100 units, or something but to just, encourage them to buy the right property and not in a gray area. And if it's gray and you're not sure, then they got to retain a lawyer, go through a process of figuring out whether or not that particular property is prohibited or not prohibited, and whether or not, and go through who the buyers are and what their plan is for exactly who's buying it, who's controlling it, and go through that process. Okay.
One other question. So say someone wants to buy a commercial property and they want to live in it. Can they do that?
And it's a commercial property. It's not a residential property, and they want to live in it.
Yeah, like say they
Gotta look at the zoning and see if they're allowed to live in it, because you're not allowed to live if it's zoned just commercial. It's a commercial property. You're not allowed to live there unless you get a
right. But if it's
zoning.
both.
Yeah, that may be a good question because, for instance, in Streetsville, um, it's residential commercial zoning. So there may be that where it's sold as a commercial unit, but you can utilize it as a residential as well. It's a tricky one. Yeah. Any other questions, guys? Yeah, so I think possibly they were coming back to our conversation from before. I think possibly they will keep it as is till 2027 for sure, as it is a liberal government and they are dealing with housing, and I think they don't want to um do anything to upset what they're trying to do with creating more housing and so on and so forth um for Canadians. Possibly they'll leave it as is, right?
Yeah, for now, I think they're going to leave it. I think we're stuck with it for a while,
Right.
and whether they extend it again, I don't know. I don't think it's high on their priority list, probably because I'm not sure how significant this all is and how much it affects it. For some of us in the industry that act for a lot of foreign buyers and have clients that, then it is significant. In our office, we've historically acted for a lot of foreign buyers, and they can't. So that has slowed us down. So I'm not happy about this law, just on a personal, from a business standpoint. Okay. And then you try and wear a different hat from a Canadian citizen standpoint. Is this a good thing? Is this keeping prices down for Canadians to buy property and allow more Canadians to buy property? Yeah, I'm not sure. And I don't think the government's produced enough studies to show that it has the effect that they intended. But we got to live with the law while it's the law, and be careful how we give advice on it, right? And if you don't like it, then talk to your local MP and complain, and find out if they're going to do something about it. Because I know, like, there's some of you in your office, and we have other agents and other offices, that a good chunk of their business is from foreign buyers. So this is really, but what a lot of them are doing is they just turn them. So, okay, they were buying residential properties, and a lot of it was GTA, and they wouldn't be outside these boundaries in those conglomerate areas. But so they've said, okay, no, you can't buy residential property now. So let's buy a commercial property, or we're putting a few together. You're going to buy an apartment building. They're finding other ways to invest in Canada. Like, don't put your hands up and say, oh, you can't buy, talk to me in 2 years when this is over. There's other opportunities. So be creative and look for other opportunities for them to buy.
Right. I'm just very quickly going to put it in there that as the city gets populated and changes, a lot of previously residential areas are are being allowed to be commercial zoning as well. We saw that in Oakville and Rebecca. It's more and more here in Streetsville. There's so many different pockets. So that availability is there. You can actually buy one of these bungalows here, and it's deemed to be commercial, right? So it's just the new use is commercial. So there is a lot of opportunity out there.
Right. So
Yeah.
never let anything like this get in the way of you trying to do business. Just, the purpose is hopefully those that attended and those that are gonna watch this later is you want to be educated, you want to understand it, you want to be able to give proper advice, you got to be careful what you're doing, and you got to be creative. But don't be, I'm not telling you to be creative and looking for ways to scheme around it and not comply, but it doesn't apply to all kinds of real estate. It doesn't apply to all kinds of areas. There are ways that your foreign clients can buy properties in Ontario and locally. Just make sure you're complying, your clients are complying with the act and getting the proper advice that they need to comply. Okay. Because there's a difference with advising them to comply and advising them to contravene. So just know the difference.
David, I just want to ask you one question. Is there any of this NRST and all of that applicable to commercial, and would that be prudent for
Nope.
us to do a? No, there's
No, no, the NRST it's
okay,
residential. It's got their own definition of what
right.
type of residential unit that it applies to, which is different than the foreign buyer ban of residential. So you got to look at the definitions every time. But it doesn't stop buying commercial property. It doesn't prevent you from buying commercial properties or
So
larger properties
there's
that
no
are, an apartment building to me is a commercial building. It's just used for residential purposes, but that's a commercial transaction. And a foreign buyer can buy an apartment, multi-unit apartment building. Okay.
and there's no commercial and there's no tax implication on it, huh?
No, no, they're only paying tax if it falls under those definitions
Residential. Okay.
of a smaller residential, smaller
Mhm.
units, right?
All right. Thank you so much, David. Thank you, everybody, for
Okay,
joining.
thanks, everybody.